As is true of many end-of-court term sessions, the decisions released today are momentous. And it's very good for Americans that both decisions today support individual liberty. When the Chief Justice, John Roberts, announced that Justice Alito would be reading both opinions today, we knew that they would be good for individual liberty. The first decision that Justice Alito summarized from the bench was in Harris v. Quinn. And the court held in that case that it struck down the Illinois law that required non-union members who take care of Medicaid patients in their own home have to pay dues to the public employee union under that law. In fact, those healthcare workers, in some sense, were not part of the union in any other respect but the requirement to pay dues, and that's what the court struck down today. The court stopped short of overruling a 1977 decision called Abood that allowed states to require non-union members to pay dues to public employee unions. But the good thing today was that the court did criticize that decision and raised a lot of questions about it. But the majority said that it would not extend that decision to the personal care workers who take care of patients in their own home. The second decision that Justice Alito summarized for the Supreme Court today is in the Hobby Lobby and Conestoga cases that involve religious liberty. In that decision, the Supreme Court struck down a Health and Human Services regulation from the United States that would require small for-profit employers to provide contraceptive services, including 4 contraceptives that could cause abortion and violated the religious liberty of those employers. The court today said that that regulation violates the Religious Freedom Restoration Act, which requires the government to have a compelling government interest and a plan that is narrowly tailored to satisfy that compelling government interest. Before the court explained why RFRA violated their religious liberty, it first decided that the for-profit employers had standing to raise the RFRA claim. And that's the point that the Pacific Legal Foundation filed its brief in support of. The court quite correctly said that for-profit businesses do have First Amendment rights of this nature to raise. The final part of the decision, in which Justices Ginsburg, Kagan, Sotomayor, and Breyer dissented from, held that the government had a much less restrictive way of allowing employees to get their contraceptives than requiring employers who have a religious objection to pay for them. And all of the decisions today were a victory for individual rights against the government that sought to deny them. As is true of almost every Supreme Court case, today's 2 decisions don't answer all of the questions that the litigants raised or are at issue in many other cases. Neither decision answered all the questions that the parties brought or that the Pacific Legal Foundation was seeking to have vindicated. So Pacific Legal Foundation's work continues, and viewers should go to pacificlegal.org to find out more about our cases and the matters that we're seeking to restore liberty from coast to coast.